You're listening to Systemic Error Podcast. The failure was designed.
Inside the Supreme Court's favorite new tool to wipe out modern laws, based on an article by Adam Lynch. The Roberts Court is not interpreting history, it is powering through it. A court disguised as an archive. The source story centers on a familiar and dangerous move from the conservative Roberts Court, teach modern legal reasoning then dress the outcome up as historical necessity. In cases like Wolford v. Lopez and Dobbs v. Jackson, the court asks not what rights protect people now, but whether a claimed right can be found buried in a nation's founding year river. That is not neutral judging. It is political power laundering itself through selective memory. Who holds the power? Then actors that matter here are not confused clerks or abstract doctrine. It is the conservative majorities on the court openly deciding which laws light and which die. The source makes that plain. The majority uses the history and tradition test to strike down laws it dislikes, including Hawaii's gun restrictions and, in Dobbs, abortion rights. This is institutional power exercising itself with a straight face. The court is not stepping back from politics. It is choosing the terms on which politics is allowed to exist. History as a weapon. The key fraud is the claim that historical analysis removes judgments from judging. It does the opposite. It narrows judgment to the court's preferred history, then pretend the result was discovered rather than selected. That is why this test is so corrosive. If the only rights that count are those deeply rooted in the 18th century, then rights protections become a museum exhibit. Contraception, gay marriage, interracial marriage, and the principle that constitutional rights can restrain state governments all become vulnerable not because they are unimportant, but because the court can refuse to recognize them as politically irrelevant. The point is not fidelity to history. The point is control over which future counts. The target is democratic lawmaking. The deeper pattern is not just judicial hostility to abortion or gun regulation. The test is being used to nullify laws passed by elected governments, including the Voting Rights Act and Hawaii's gun legislation. That matters because it shifts the center of gravity away from democratic lawmaking and toward unelected judicial veto. This is where the source is strongest. The court is no longer reframing around the edges of enumerated rights. It is using history to overrule progressive legislation itself. That is not restraint. It is a consolidation tactic. Reform is not a thought experiment. The article ends by pointing toward court reform if Democrats retake the House. That is not wrong, but it is too polite for the scale of the problem. The issue is not whether the court has become ideological and unbalanced. It is that a conservative majority is claiming the authority to invalidate whatever law does not fit its politics. That is the institutional reality Democrats have to confront, not with ritual respectability but with power, court reform, democratic counterweight, and a refusal to treat judicial sabotage as principled disagreement. The system beneath the doctrine. The larger pattern is simple. Reactionary institutions rarely announce themselves as reactionary. They announce themselves as faithful, restrained, historical, and serious. Then they use those labels to strip rights, weaken elected government, and naturalize the outcome as if no one chose it. The Roberts Court chose it. The test is the disguise. The consequence is a constitutional order where history is invoked not to understand the past, but to discipline the present. You've been listening to Systemic Error. Thanks to Ultimate for today's article. With the automated voice of Diana, thanks for listening.